Legal implications for homeowners lenders. Holding second liens, also known as junior liens, face several risks, especially when the borrower defaults or the property is sold in a foreclosure or short sale. Here are some key risks for lenders in second liens and unpaid junior liens. Subordination. Risk definition. A second lien is subordinate to the primary mortgage, first lien, meaning that the first lien holder has priority in getting paid if the property is sold or foreclosed. Risk. If the property sells for less than the outstanding amount of the first lien, the second lien holder may not receive any payment. This is especially true in cases where the sale price is lower than the total debt owed, leaving the second lien holder with little to no recovery. Unsecured debt risk definition. When a borrower defaults, the second lien is often left as unsecured debt if the value of the property is insufficient to cover both the first and second liens. Risk. If the property sale doesn't cover both liens, the second lien lender may be left with an unsecured claim. This means they may have to write off the loan as a loss or seek repayment through other methods, which can be difficult to enforce. No recovery in foreclosure definition. In a foreclosure, the first lien holder is paid first, and the second lien holder only gets paid if there are remaining funds after the first lien is satisfied. Risk. In many cases, a foreclosure results in the second lien lender getting nothing if the foreclosure sale proceeds only cover the first lien. This makes second liens more vulnerable, especially in distressed property situations. Deficiency judgment. Risk definition. A deficiency judgment occurs when the sale proceeds don't cover the total loan balance, and the lender sues the borrower for the remaining amount. Risk. While first lien holders have more options to recover the balance, second lien holders may struggle with deficiency judgments, especially if the borrower is financially strained and unlikely to repay the balance. Furthermore, some states have anti-deficiency laws that prevent second lien holders from pursuing deficiency judgments in certain circumstances. Tax liability risk definition. If the second lien is forgiven as part of a short sale or negotiated settlement, the borrower may face tax liability on the forgiven amount, treated as income by the IRS. Risk. While this doesn't directly affect the lender, it can complicate negotiations for second lien holders. If the borrower faces a tax burden due to debt forgiveness, it may make the borrower more resistant to a short sale or settlement, delaying or complicating the lender's recovery efforts. Extended timeline for recovery. Definition. Second lien holders often face a longer timeline to collect on their loans, especially if the borrower is in default. Risk. Due to the subordinate position of the second lien, the lender may face delays in getting repayment, as they must wait for the primary mortgage lender to take action first. This prolonged timeline increases the risk of the borrower declaring bankruptcy, or the property's value decreasing further. Bankruptcy risk definition. If the borrower files for bankruptcy, second lien holders are typically in a weaker position to recover their loan balance. Risk. In bankruptcy proceedings, second lien holders may be classified as unsecured creditors, reducing the likelihood of repayment. Additionally, if the borrower's assets are insufficient to cover the debt, second lien holders may receive little to no recovery. Limited control over foreclosure process. Definition. A second lien holder usually has limited control over foreclosure proceedings because the first lien holder typically takes charge of the process. Risk. If the property is foreclosed upon, the second lien holder may not have the ability to influence the timing, terms, or potential sale price. This lack of control can increase the risk that the second lien holder will not be repaid. Risk of strategic default definition. In some cases, homeowners may choose to strategically default on the second lien if they feel that the home's value is too low to justify keeping both loans. Risk. This increases the likelihood that the second lien will go unpaid, forcing the lender to either negotiate a settlement or pursue the borrower for the debt, often with limited success. Market conditions. Risk definition. The value of the property and the overall market conditions heavily influence the recovery potential for second liens. Risk. If the real estate market declines, the second lien holder's chances of recovery diminish. In a depressed market, even foreclosure may not generate enough funds to cover the first lien, leaving the second lien holder with nothing. In summary, second lien holders face a higher level of risk compared to first lien holders due to their subordinate position, limited control in foreclosure, and the possibility of not recovering any funds if the property's sale price is insufficient to cover both liens. They are also exposed to the risks of borrower bankruptcy, strategic default, and tax liabilities resulting from forgiven debt. Legal implications for homeowners. The legal implications for homeowners involved in short sales, foreclosure, and second liens are significant, as these processes can have lasting effects on their financial and legal standing. Here are some key legal implications. Deficiency judgment risk. Definition. A deficiency judgment is a court order that requires the borrower to pay the remaining balance of a loan after a foreclosure sale or short sale. Legal implications. Homeowners may be legally obligated to pay the remaining debt even after the property is sold. This risk is higher in foreclosure cases, as lenders may pursue deficiency judgments for unpaid balances. However, some states have anti-deficiency statutes that prevent lenders from pursuing deficiency judgments after foreclosure on certain types of residential property. Impact of anti-deficiency laws. Definition. Anti-deficiency statutes limit the ability of lenders to seek a deficiency judgment following the foreclosure of certain types of residential properties. Legal implications. Homeowners in states with anti-deficiency laws may be protected from liability for the remaining debt after foreclosure, but this protection does not typically extend to short sales. In a short sale, the homeowner may still be liable for the remaining balance if the lender requires it, unless the homeowner negotiates debt forgiveness or the lender releases them from liability. Tax consequences. Forgiven debt. Definition. The IRS may treat any forgiven debt in a short sale or foreclosure as taxable income. Legal implications. Homeowners may face legal obligations to pay taxes on the forgiven debt if it is considered income. For example, if a lender forgives a portion of the loan balance in a short sale, the borrower might receive a 1099-C form from the lender. This forgiven debt could then be taxed as ordinary income, leading to a potential tax liability. However, certain exemptions, such as the Mortgage Forgiveness Debt Relief Act, may provide relief in some cases. Bankruptcy and discharge of debts. Definition. Bankruptcy allows homeowners to discharge certain types of debt and obtain legal relief from creditors. Legal implications. If a homeowner is facing significant debt after a short sale or foreclosure, filing for bankruptcy may be an option. Bankruptcy can discharge unsecured debts, such as deficiency judgments, and prevent creditors from taking further legal action to collect. However, filing for bankruptcy has long-term credit and legal implications, including the loss of assets and potential challenges to rebuilding financial stability. Unsecured promissory notes in short sales. Definition. In some short sale agreements, the lender may require the homeowner to sign an unsecured promissory note for the difference between the sale price and the loan balance. Legal implications. If a homeowner agrees to an unsecured promissory note, they may be legally obligated to repay the lender for the deficiency amount. If the homeowner fails to pay, the lender could potentially take legal action, such as pursuing a lawsuit for the remaining balance or attempting to collect through wage garnishment or other means. Loss of property and rights. Definition. In both foreclosure and short sales, the homeowner may lose their property, either through a sale or deed transfer. Legal implications. The homeowner loses their right to the property and may face legal challenges to retrieve or regain ownership, especially if there are disputes regarding the terms of the sale or mortgage. In foreclosure, the homeowner typically loses the right to remain in the property unless they can redeem the property by paying off the loan in full in some states. Eviction risk post-foreclosure definition. After a foreclosure, the homeowner may be subject to eviction if they continue to live in the property. Legal implications. Once the lender takes ownership of the property, the homeowner may face eviction, which can result in legal proceedings. This eviction process can be stressful and complicated, and in some cases, homeowners may be able to negotiate with the lender for more time to vacate the property. Title issues and liens. Definition. During a foreclosure or short sale, the homeowner may have to deal with issues related to unpaid liens on the property. Legal implications. If there are junior liens, second mortgages, or other debts secured by the property, the homeowner may face legal action from those lien holders if the liens are not satisfied during the sale. In short sales, the homeowner may have to negotiate with these lien holders to avoid further financial responsibility. In some cases, if a lien holder agrees to a short sale, they may still pursue the homeowner for the remaining balance on the lien. Breach of contract in short sales. Definition. A short sale agreement is a contract between the homeowner and the lender, and breaching the terms can have legal consequences. Legal implications. If the homeowner breaches the terms of the short sale agreement, e.g., by failing to fulfill required payments on an unsecured promissory note, they could be sued by the lender for breach of contract. This could lead to further financial and legal consequences, including garnishment of wages or other collection actions. Consumer protection laws. Definition: homeowners are protected by various consumer protection laws that govern the foreclosure and short sale process. Legal implications. Homeowners have legal rights that protect them from certain unfair or deceptive practices during foreclosure or short sales. These laws ensure that homeowners are treated fairly and that the lender follows proper legal procedures. For example, lenders must follow specific steps before foreclosing, and they must provide accurate information about any debt forgiveness or deficiency judgments. Conclusion. The legal implications for homeowners involved in short sales, foreclosures, or dealing with second liens are complex and can lead to lasting financial and legal consequences. Homeowners must understand their rights and obligations under state and federal law, particularly regarding deficiency judgments, taxes on forgiven debt, bankruptcy options, and potential risks from unsecured promissory notes. Seeking legal advice is often essential to navigate these challenges and protect one's financial future. Federal law on deficiency judgments and taxes on forgiven debt. Deficiency judgments, federal law overview. There is no single federal law that governs deficiency judgments, as these are primarily regulated by state laws. However, some federal regulations impact how lenders handle deficiencies. Dodd-Frank Wall Street Reform and Consumer Protection Act, 2010, imposes stricter regulations on mortgage lenders and servicers to ensure transparency in foreclosure and short sale processes. Prevents lenders from misleading borrowers regarding deficiency judgments or loan modifications. Fair Debt Collection Practices Act, FDCPA, regulates how lenders and debt collectors can pursue deficiency judgments. Prohibits abusive, deceptive, or unfair debt collection practices. Service Members Civil Relief Act, SCRA, provides protections for active duty military personnel from foreclosure and deficiency judgments. Although deficiency judgments are handled at the state level, federal laws provide protections against abusive collection practices. Taxes on forgiven debt, federal law. When a lender forgives part of a homeowner's mortgage debt, e.g., in a short sale, foreclosure, or loan modification, the IRS generally considers this taxable income under Internal Revenue Code, IRC, Section 61A, 12. However, there are exceptions. Mortgage Forgiveness Debt Relief Act, MFDRA, 2007. Extended through 2025, exempts up to $750,000 of forgiven mortgage debt, $375,000 for married individuals filing separately, from being taxed if the loan was used to buy, build, or improve the taxpayer's primary residence. The forgiven debt resulted from foreclosure, short sale, or loan modification. Insolvency exclusion, IRC Section 108A, 1b. If a borrower is insolvent, i.e., total debts exceed total assets, at the time the debt is forgiven, the forgiven amount may be excluded from taxable income. Bankruptcy discharge, IRC Section 108A, 1a. If mortgage debt is discharged through bankruptcy, it is not considered taxable income. Qualified principal residence indebtedness, QPRI, exclusion. Under the MFDRA, if the forgiven debt is tied to a primary residence, it may qualify for tax exemption. However, debts from investment properties do not qualify. Wheel title. Under the MFDRA, if the forgiven debt is tied, phrase, to a primary residence. Key takeaway: while forgiven mortgage debt is generally taxable, homeowners may qualify for exclusions under the Mortgage Forgiveness Debt Relief Act, insolvency rules, or bankruptcy provisions. A little more on Arizona deficiency. Arizona laws on deficiency judgments and taxes on forgiven debt. Deficiency judgments in Arizona. Arizona has strong anti-deficiency laws that protect certain homeowners from being sued for a deficiency judgment after foreclosure or a short sale. These laws are primarily found in the Arizona Revised Statutes, ARS, paragraph 33-729 and 33-8114. ARS, paragraph 33-729, anti-deficiency protection for judicial foreclosures, mortgages, applies to purchase money loans, loans used to buy a home, not refinances or home equity loans. Protects homeowners from deficiency judgments only in judicial foreclosures. Covers single-family homes and duplexes on 2.5 acres or less, provided they were used as the borrower's primary residence. ARS, paragraph 33-814G, anti-deficiency protection for non-judicial foreclosures, trustee sales, applies to trustee sales, non-judicial foreclosures, which are the most common foreclosure method in Arizona. No deficiency judgment is allowed if the property meets both conditions. It is a single family or duplex. It sits on 5 acres or less, and was used as the borrower's primary residence. If the borrower refinanced or took out a home equity loan, the lender may still be able to seek a deficiency judgment. When can a lender pursue a deficiency judgment in Arizona? If the property is not a single family or duplex, e.g., commercial or multi-unit property. If the land is larger than 2.5 acres. If the loan was a refinance, second mortgage, HELOC, or cash-out loan. If the borrower voluntarily waived anti-deficiency protection in the loan agreement, common in commercial loans. Fair market value rule. If a lender is allowed to seek a deficiency judgment, Arizona law limits it to deficiency judgment limitations, fair market value rule, ARS, paragraph 33-8114A. If a lender can pursue a deficiency judgment, the amount is limited to the difference between the loan balance and the fair market value of the property at the time of the foreclosure sale. Borrowers can challenge the lender's valuation in court if they believe the property was sold for less than market value. The difference between the loan balance and the fair market value of the property at the time of the foreclosure sale. Borrowers can challenge the lender's valuation in court if they believe the home was sold below market value. Deficiency judgments in short sales. Arizona's anti-deficiency laws do not automatically apply to short sales. Lenders can seek a deficiency judgment after a short sale unless the borrower negotiates a written waiver. Borrowers should ensure that the short sale approval letter from the lender includes a clause stating that the debt is fully satisfied and no deficiency will be pursued. Taxes on forgiven debt in Arizona. While deficiency laws protect many Arizona homeowners from lawsuits, forgiven mortgage debt may still be taxable unless certain exemptions apply. State tax treatment of forgiven mortgage debt. Arizona generally follows federal tax rules regarding forgiven mortgage debt. If the IRS considers forgiven debt taxable, Arizona will also treat it as taxable income unless an exemption applies. Exemptions from taxes on forgiven debt. Under federal law and Arizona tax law, which follows federal guidelines, homeowners may avoid taxation on forgiven mortgage debt if Mortgage Forgiveness Debt Relief Act, MFDRA, extended through 2025. Forgiven debt on a primary residence may be excluded from income tax up to $750,000, $375,000 for married filing separately. This applies to short sales, foreclosure forgiveness, or mortgage modifications, does not apply to investment properties or second homes. Insolvency exclusion, IRC Section 108A-1B. If the borrower is insolvent, meaning total debts exceed total assets, at the time the debt is forgiven, they may not have to pay taxes on the forgiven amount. Arizona follows federal insolvency rules. Bankruptcy exclusion, IRC Section 108A-1A. If the mortgage debt is discharged in bankruptcy, it is not taxable under federal or Arizona law. Arizona Department of Revenue, ADOR. Treatment. Arizona generally conforms to IRS rules regarding mortgage forgiveness. Borrowers should check with a tax professional to ensure they qualify for state and federal exemptions. Key takeaways for Arizona borrowers. No deficiency judgments after a trustee sale, foreclosure, if the property is a single family or duplex on 2.5 acres or less, and was the borrower's primary residence. Deficiency judgments are possible if the loan was a refinance, second mortgage, or cash-out loan. Short sales do not automatically prevent a deficiency judgment. Borrowers must negotiate a waiver with the lender. Forgiven debt may be taxable unless the borrower qualifies for an exemption under the Mortgage Forgiveness Debt Relief Act, insolvency rules, or bankruptcy laws.